So yesterday, February 7th, 2013, is one of those really disturbing days as an American, and frankly, even more disturbing as a lawyer. We're raised from a very young age to believe that this country is a good and honest country, that we're governed by a system of laws and rules, and that the elected representatives and those people who are up in Tallahassee and in leadership roles exist to protect the larger good, support the rule of law in the general public. But what we saw on display yesterday was the reality of this country today, and that is the banks, the financial services industry, the insurance industries, all ruling the country over the interests of the American people. And the two events in particular that come together to make yesterday such a bad day are earlier in the day, the Florida House of Representatives Subcommittee on Civil Justice met to consider House Bill 87. And then later in the day, the Florida Supreme Court released their opinion in Pino versus Bank of New York. Now, it's great to be able to watch these committee meetings live on television. I encourage everyone to log onto their computer when they exist and really follow this House Bill 87. It was a real pleasure to see lots of consumers up there speaking their mind and being engaged in the process. That's a good thing. But what you saw was a parade of lobbyists up there who were supporting this bill and really pushing this thing through. And it's really disturbing because what this bill is really about right now is the title insurance industry seeking to protect themselves from claims that they might experience for the wrongdoing that has occurred in the conduct of foreclosure cases. I guess one bright point about this debate over House Bill 87 is here we are in 2013, and everybody that is in any position of leadership or knowledge is outright acknowledging what we on the defense and advocacy and consumer rights side of this argument have been saying for many years, and that is the entire process is polluted and infected from its core with fraud and forgery. And this really is, I suppose, a victory, because for the many years that we've been going up there to Tallahassee, and I remember those early years when there were small groups of people up there screaming on the courthouse steps, no one was listening to us, save a few legislators and like-minded policy people. I give Senator Darren Soto, now Senator Darren Soto, big credit there, because early on he was listening to these kind of things. But again, early on, no one was paying attention to this. People were ignoring the fraud and the forgeries that exist and pollute our court system from one side of the state all the way to the other. But here we are in 2013, and there was outright open acknowledgement that our entire court system, the entire foreclosure court system, is infected and polluted with fraud from beginning to end and all the way through. And so that acknowledgement is now making its way into the public policy discussion, and it is the one impetus between the most important force behind House Bill 87 right now, and that is the title insurance industry. Now, the title insurance industry was more than happy to collect insurance premiums for all of these years from their agents, and knowing full well that their agents were engaging in improper conduct, that they were cutting corners, forging documents, producing fraudulent documents, and then maybe just engaging in reckless procedures. So it ranges a spectrum. But the reality is the title insurance industry, knowing full well that their agents were out there writing these policies based upon these improper documents, now they're asking the legislature to get them a get-out-of-jail-free card. So the legislature sat by idly and allowed them to engage in this reckless and improper conduct, collect all these premiums. And now when there's some potential of harm or some potential of claims to be paid, now the title insurance industry is going to the legislature and saying to our elected representatives, hey, change these contracts and don't put us on the hook for the real liability here. Classic insurance industry, but that's exactly what's happening. Now, it's disturbing to hear them go to Tallahassee and assert that the reason they're there is in the public interest. They want to protect that mythical homeowner who bought a home out of foreclosure and risks being thrown out of it because it's proven at some point in time later that the agent that got the foreclosure engaged in fraud as a product of that. Now, look, the reality is, unfortunately, the window of time for them to make that claim is 1 year. You only have 1 year after a fraudulent, improper judgment to have that judgment overturned. And so that fear that they have, that great fear, is a very, very narrow universe. But again, it's quite strange to hear the hired guns of the lobbying industry up there asserting that they represent the interests of consumers when in fact they don't. What this really is about is the title insurance industry does not want to be subjected to title insurance claims for the wrongdoing that their agents have engaged in. And that's disturbing to me, but we'll see what Tallahassee does. One thing's for certain, they are going to pass this bill out. And the disturbing thing is, not enough consumers are involved or aware. We had just a couple of consumers up there, and again, good work for those folks, but no one really cares about this, and so something very bad is going to happen. They are going to pass that out. So then later in the day, the Florida Supreme Court issues their opinion in Pino versus Bank of New York. And again, terribly, terribly disturbing, because when you read the opinion, I think the thing that disturbed me so much about it is the opinion is a very hyper-technical and narrow dissertation on a particular element of the rules of civil procedure. Rather than addressing the larger context in which the opinion was brought to the court, the case was brought to the court took a very narrow opinion to just say the rules of civil procedure do not allow the court to issue the kind of relief that Tom Ice and his client sought. And, you know, that to me is what's disturbing. Throughout this opinion, we have, again, an ignoring of the larger context in which that opinion was brought. I find it disturbing that the opinion took the time to assert that Roman Pino was in default on his mortgage, and so I suppose somehow that provides the justification for all of the bad conduct that was occurring, and yet there was no treatment of the wrongdoing that occurred on the other side of the case, and that was the bank and the lawyers that were hired by the bank producing these improper documents and then using that as a means to try and gain a foreclosure judgment. That's what I found disturbing. And I would have liked to read at least one dissent in that opinion where one justice says, you know, I recognize the larger context in which this opinion is brought to the court. And while I don't like the way the rules operate, we're going to issue this opinion and provide some guidance to say we as the Florida Supreme Court want to see more truth, want to see more justice occurring in the space of foreclosure, but we see absolutely none of that. And in fact, there is a glaring error that occurs within the opinion that completely misstates the Florida Supreme Court's own rule on one particular subject. But that's a passing point that really doesn't matter in the larger context of things. So what do we have when we put those two events together? Let's combine the Florida House Bill 87 and Roman Pino. Florida House Bill 87 says that if you produce fraudulent documents, if you engage in fraud, forgery, improper conduct as a means to gain a judgment, whether it be foreclosure or anything else, and that's an important point to make, but if you engage in fraudulent, improper conduct in the context of a civil litigation case, and if you get caught doing that, all you need to do is dismiss the case, and there will be no consequence or no penalty. So again, think about this in the larger context. In a criminal prosecution, I suppose, a prosecutor or whatever can fabricate documents, can create false evidence, and if the defense attorney catches them on that, all they have to do is, do a voluntary dismissal. The case is open, obviously not in a criminal context, but in any other civil litigation case. Multi-million-dollar securities case. The plaintiff files a case. All they got to do is fabricate evidence. In fact, they can fabricate evidence. Submit that evidence in front of the court. And then if the defense attorney finds them doing this, all the plaintiff's attorney has to do is file a notice of voluntary dismissal very quickly. The case is over. The court can't do anything, and also they got away with it. Well, let's now put this in the context of foreclosure. The plaintiffs can fabricate evidence, forge evidence, falsify evidence, submit these in their cases all across the state. And if no one catches them doing that, then they get a final judgment of foreclosure. With House Bill 87, they use that fabricated, forged, false evidence to obtain a false judgment of foreclosure. That judgment is entered. There's nothing at all that a homeowner can do to revoke that final judgment of foreclosure. So think about it in that context. They use all this false evidence, fabricated evidence. They get a final judgment of foreclosure. The moment the judge bangs down that gavel, bam, final judgment entered, and there's nothing the homeowner can do to get that property back. This family that's lived in a home for generations, a family farm, hundreds of years, they're in Central Florida. Kids were raised on it. Grandparents were raised on it. Parents were raised on it. But some out-of-state New York corporation wants that property. And so they fabricate, forge, and falsify documents in order to get that property. They grease this through the system. A final judgment of foreclosure is entered. Bam. The moment that final judgment is entered, it's final. And after the 30-day appeal process is run, it's final. And now there's nothing at all that that family could ever do to get that property back, that home that's been in their family for generations. Now, they would say to you that there is a remedy. You can get a money judgment and you can get that property back. Well, think about it this way. What if the plaintiff that has engaged in that scheme to defraud the family out of their home is some shell corporation, the XYZ corporation, set up specifically to take this property back? They forge, they fabricate, they fraud, they produce fraudulent documents. They get that property back. Final judgment's entered. 30 days have passed. Title is now in the forged and fraudulent corporation. They immediately convey that out to another party. Now that land is owned by a party that is not at all associated with the corporation that produced all that fraud, and there's no one to recover from. That's what you get when you combine Pino versus Bank of New York and Florida House Bill 87. Folks, it's a terrifying, scary world that we live in out there. And unfortunately, the advocates that are out there standing up for justice and for consumers are under attack like never before. Attorneys that walk into courtrooms and dare to challenge the banks and institutions from one end of the state all the way down to the other are subject to attack by plaintiffs' attorneys and from a judicial system which is outright hostile to what they're trying to do. In the legislative scene, there just aren't resources for consumer advocates and for people who care about justice to go up there and fight. And frankly, legislators aren't listening because they're beholden to the campaign contributions and the larger interests of the banks and the institutions that are out to do one thing, and that only is to fatten up their own corporate profits and their own corporate interests. Terrifying world that we live in, folks. And unfortunately, the end product of all of this is a judicial system which is moving more quickly than ever before to throw homeowners out into the street. We see this here locally and all over the state. The rocket dockets, as a result of the funding that the banks paid to the court system from the settlements, they're using that funding to set up hearing times, which are then having the courts go and grab old files that have been laying languishing since 2010, 2011. They're setting those for final judgment. They're setting those for trial. They are focused almost exclusively on granting final judgments. Those final judgments are going to result in sales. And what's going to happen is thousands of Floridians who have lived in their home under this false sense of security are going to find the sheriff showing up at their door to tell them, get out. It's a sad consequence. It's unfortunately the consequence we've been warning about for many years now, but perhaps that's what it's going to take for consumers to finally wake up and recognize how much they need consumer rights attorneys and people out there defending and protecting them. There aren't nearly enough of them, and those that are unfortunately suffering severe consequences, penalties, and attacks, but no one's there to support and defend them. I hope that at the end of the day, we'll all come together and support a more just and fair country, and particularly in the state of Florida, because right now, frankly, it just doesn't exist.